Hello everyone, my name is Satyam Shivaach and I am working as a legal intern with LEXIS and Company. And in this video, we will discuss about anticipatory bail. The term anticipatory bail is nowhere defined in the Criminal Procedure Code 1973. However, the first mention of the said term can be seen in the 41st Law Commission report in 1969, where the Commission felt that the need to include a provision for protecting an accused or any person who is apprehending or having a belief that he or she may be arrested for any offence which is non-bailable in nature. Taking into consideration the said report and the grave need of the hour, the Parliament, by enacting the 1973 Act, added a provision of pre-arrest bail under Section 438 with the heading of Direction for a grant of bail to a person apprehending arrest. Now let's see the evolution of anticipatory bail. The origin of the bail dates back to the medieval time when the first known draft constitution came into enactment in the year 1215 by the King John of England. The genesis of the bail can be extracted from the clause 39 of the Magna Carta, the simple translation of which reads, "No free man shall be seized or imprisoned, or stripped of his right of possession, of outlaw or exiled, or deprived of his standing in any other way, nor will he proceed with force against him, or send other to do except any lawful judgment of his equal, or by any law of the land." For a pursual of this clause, it can be understood that a person shall not be restricted or confined unless and until he has a final judgment in accordance with the law of land. On a careful reading and decoding of this clause, we can greatly relate to the said provision with the provision of bail under the provided CRPC. The old CRPC of 1898 did not have any provision for anticipatory bail. As mentioned above, the idea of anticipatory bail or pre-arrest bail was first recommended by the Parliament on the 41st Law Commission report. Now let's see the section 438 of the CRPC, which gives direction for grant of bail to a person apprehending arrest. The clause 1 says, when any person has a reason to believe that he may be arrested on the accusation of having committed a non-bailable offence, he may apply to High Court or the Court of Session for a direction under this section, and the court may, if they think fit, direct that in the event of such arrest, he shall be released on bail. Clause 2 says, when a High Court or the Court of Session makes a direction under subclause 1, it may include that such condition in such direction in the light of the fact of the particular cases, as it may think fit, which including subclause 1, a condition that a person shall make himself available for interrogation by the police officer and when required. Second, being a condition that a person shall not directly or indirectly make any inducement, threat or promise to any person acquainted with the fact of the case so as to dissuade him from disclosing such fact to the court or any police officer. Third, being a condition that a person shall not leave India without any prior permission of the court. Fourth, being such other condition may be imposed upon subsection 3 of the section 437 as if the bail were granted under that section. Clause 3 states that if such person is thereafter arrested without a warrant by an officer in charge of a police station on such accusation, and is prepared either at the time of arrest or any time while in the custody of such officer to give bail, he shall be released on bail, and if a magistrate taking cognizance of such offence decides that a warrant should be issued in the first instance against that person, he shall issue a bailable warrant in conformity with the direction of the court under subsection 1. Now let's see the filing anticipatory bail application. It is advisable to engage a criminal lawyer once a criminal complaint or an FIR has been lodged. Once engaged, a suitable course of action including the application of pre-arrest notice bail or anticipatory bail can be decided upon. Once decided, the lawyer would draft an anticipatory bail, mentioning the reason of the bail and your version of the facts surrounding the matter. The application of the bail is then made at the appropriate session court. And when the matter comes up to the hearing, the lawyer must appear and present the case. If the judge sees that the case has fit, the anticipatory bail is provided to the accused. In case of the anticipatory bail application is rejected in the session court, the application can be made to a higher court. And if the High Court also rejects the bail, the application can be made before the Honorable Supreme Court. Now let's see what are the conditions needed for the anticipatory bail. Starting with the available of the interrogation of the police officer when required, Second being the person shall not directly or indirectly induce or or make promise to any person acquainted with the fact. Third being the person shall not leave the nation without any prior permission of the court. Now let's see some of the recent landmark judgment on the anticipatory bail. The first case is Sushila Agarwal vs State of Delhi. In this honorable court was pleased to frame two questions while deciding this landmark judgment. First was whether the protection granted to a person under section 438 of the CRPC should be limited to a fixed period or so as to enable a person to surrender before the trial or seek regular bail. And the second question was whether life of anticipatory bail should end at the end stage when the accused is summoned to the court. The constitutional bench of the apex court was pleased to answer the first question by holding that there can be no time limit to set for the anticipatory bail by the court granting the same. The five-judge bench was pleased to unanimously hold that the protection granted to the person under the section 438 of CRPC should not invariably be limited to a fixed period. It should ensure in favor of the accused without any restriction or time. In answering the second question, the Honorable Court held that the life or the duration of the anticipatory bail order does not end normally at the time and stage when the accused is being summoned by the court and when charges are being framed, but can continue till the end of the trial. Again, if there is any special or peculiar feature necessitating the court to the time limit to tenure the anticipatory bail, it is open for it to do so. The Supreme Court was cautious while answering the second question by granting discretionary power to the court to limit the tenure of the anticipatory bail in the case of special or peculiar fact of the case. Now, Honorable Court in Badresh Bipin Bal said versus State of Gujarat was pleased to hold that the provision of anticipatory bail enshrined in Section 438 of the Code is conceptualized under Article 21 of the Constitution, which relates to personal liberty. Therefore, such a provision calls for liberal interpretation of Section 438. The court explained that the anticipatory bail is a pre-arrest legal process which directs that if a person is in whose favor it has been issued is thereafter arrested on the accusation in respect of which the direction is issued, he shall be released on bail. The apex court, while observing the above, celebrates the two provisions and related them together. The court was pleased to observe that the Section 438 and Article 21 goes hand in hand, and that by enacting the provision for granting of anticipatory bail, the legislature will upheld the fundamental right of the citizens. That is all for today's video. Thank you for watching. Please like, share and subscribe.